Hearing preparation, witnesses, and documents. My name is Robin Coker. I'm the Director of Communications at Disability Rights Florida. I'm a white woman with blonde hair, wearing glasses and a green-colored shirt. On the screen, we have a PowerPoint slide with a purple background and orange and white graphics and lettering. The speaker for today's webinar is Caitlin Clibben, an attorney and Disability Rights Florida's Director of Community and Health Services. First, we will review the accessibility features of this webinar. The webinar has closed captions and American Sign Language. Closed captions are available at the bottom of your screen by using the button that says CC. In the chat, there will be a link to view the external caption. You can click on that link to have your captions appear in a separate window on your computer. We have 2 American Sign Language interpreters today. They are spotlighted on your screen and should be visible at all times. If you cannot find them, make sure your participants setting shows all video participants. If you have questions during the webinar, please submit them in the Q&A. The Q&A button is at the bottom of your screen. You can also send your questions to the email address webinar@disabilityrightsflorida.org. Lastly, this webinar will be recorded and posted on our website and YouTube channel. Now that we have the housekeeping complete, I will pass things along to our speaker, Caitlin, who will begin by providing a brief overview of Disability Rights Florida and the agenda for today's webinar. Go ahead, Caitlin.
Hi, everyone. Thank you, Robin. I'm Caitlin Clibben, Director of Community and Healthcare Services at Disability Rights Florida. And I'll be talking about preparing for hearing as far as it goes with witnesses and documents. I'm a white woman with brown hair tied in a knot on top of my head, wearing a white or a black sweater. Okay, so just a little bit about DRF. We are the protection and advocacy system for Florida. We have funding, responsibility, and authority under 9 federal programs to protect the rights of people with disabilities in Florida. We've been a not-for-profit corporation since 1987, and we have offices in Tallahassee, Tampa, Gainesville, and Fort Lauderdale, though we serve people statewide. So the mission of Disability Rights Florida is to advocate, educate, investigate, and litigate to protect and advance the rights, dignity, equal opportunity, self-determination, and choices for all people with disabilities. So in this presentation today, we're going to learn kind of 4 general topics. How to identify which witnesses you're going to call if you're going to a fair hearing. How to think about what questions to ask each of your witnesses. A little bit about cross-examining witnesses from the other side. And how to identify which documents to use at your fair hearing. So first, on witnesses. So just for context, what we're talking about is you've requested some sort of, service or hours or something like that, personal care hours, PPEC services, something like that, and you've gotten your denial, you've requested your fair hearing, they've sent you your notice, my hearing's coming up, and so now you're getting prepped. So you want to think about how to present your case, and you're going to do that mainly through documents and witnesses. And so the first thing to think about is, who to call. And who you call is wholly dependent on what it is you're trying to prove. So different people here may have, different things that they are trying to get, whether it be, hours or durable medical equipment. So it'll be, this is going to be context specific, but I'm going to do my best to give you concepts that will apply, regardless of what it is you're seeking. So once you've, requested your thing, your service, and you've gotten that denial letter, that letter is your first clue as to how to proceed to strategize your case. So in the denial, it's going to have some sort of explanation for why they denied you, what it is that you didn't show that you needed to show to get what you're asking for. So that's what you're going to try to disprove. You're going to need to combat whatever that says. And then the other place you're gonna look is in the general rules about the service you're requesting. So, every, a Medicaid service has to be medically necessary. So you need to look at what makes this particular thing you're requesting medically necessary, and that's what you need to prove. If you're applying for the ABD waiver under autism, you've got to prove 6 of 12 factors. So you're gonna pick your 6 or 7 or 8 factors you think you can prove, and those are the things you're gonna want to show at hearing. So like I said, very case dependent, but you're looking at the requirements for the thing you've requested, and then also the denial letter are your main places to look to start thinking about how to strategize. And just some general information about picking witnesses. A professional is going to be considered, a more neutral witness, more credible, trustworthy, than someone who's very close to you, a friend, family member. So when available, when possible, if you can get your evidence or your proof from a professional, or someone who's not connected to your family, that's going to be your better witness. And again, and also the longer the history they have with the applicant, the better. So the person who's seeking the service or seeking the item, that person, if you've got a therapist who you've only known 2 months and you've got one you've known 2 years, the one you've known 2 years is most likely going to be able to give the best evidence. Okay. So here I have a case example, and I'm going to use this example to kind of talk about what I was just discussing. So I'm sorry, I need to move my little thing. Okay, so in this case example, we have Alex. Alex is a 10-year-old with autism. She displays repetitive behaviors, hyperfixation on certain objects, only speaks in single words, and sometimes engages in self-harm. She's also eloped multiple times, with the police being called twice. Alex's parents applied for the iBudget waiver through APD. They received a denial letter. It states there is not enough evidence to show Alex's autism is severe and pervasive. The denial points to IEPs from Alex's school that say Alex is friendly, engaging, and loves to learn as evidence that Alex's autism is not severe or pervasive. The denial also says that Alex's behaviors and symptoms associated with her autism may improve with services available through the school or the community. Alex's parents appealed the denial, and they are going to be representing her at fair hearing. So I have a poll question to get an idea of what people are thinking about. Here it is up on the screen. So the first poll question, you can pick multiple choice. You can pick more than one of these choices. So which witnesses might Alex's parents call to testify at the hearing? And your options are Alex, Alex's parents, Alex's teacher, Alex's school behavior specialist, Alex's primary care physician, or a police officer. So everyone should go ahead and vote what you think, who you think would be. And like I said, you can pick more than one, you can pick all of them, whatever you think. And Keith, I'm going to let you control the poll and decide when to close it and give me the answer, because I can't see how people are, or how many people have responded. Okay, all right. So here are our answers. It looks like most people agreed that the school behavior specialist should be called. The next highest was the primary care physician, teacher, parents, and then 2 people said Alex and the police officer. So that's about what I would say, I think. So I'm gonna, if I can leave this here, hopefully. Oh, nope, I can't. Okay. So in this situation, as far as calling Alex, I probably wouldn't unless it was entirely necessary, because these hearings can be long and boring and difficult, and making a 10-year-old sit through that is not generally my style. Alex, oh, thank you for putting that back up. For Alex's parents, I think it's likely at least one of Alex's parents is going to need to testify, because they will have all that good day-to-day information and really be able to put context on, the data points and the, little paragraphs you read in therapy reports and that sort of thing. The parents can really it fleshed that out. I'm Alex's teacher and Alex's behavioral specialist. So in my head, I'm assuming both of these people work with Alex at school. If I can get all the information I need out of just one of them, I will probably just call one of them. Having two different people testify to the same thing doesn't make your case any stronger if it's really the same information. So, you know, it would kind of depend here. So I would call both of them. I would want to speak to both of them. And if one of them has information the other doesn't, you know, if they each have their own unique information, then I might need to call them both. If they both have the same information and one has a little more, I'll call the one with a little more. As far as the primary care physician, I may or may not call the primary care physician. It kind of depends. And there's a little trick question here, because if Alex had a specialist that they were working with that had done an evaluation and I was using that evaluation at my hearing, I would want to use that doctor more than the primary care physician. You know, our primary care physician is talking about bumps and bruises and colds and annual shots and that sort of thing. And if I had a specialist in the wings, I would prefer that over the primary care. But if there was medical information that I needed to put in front of the hearing officer, and I don't have that specialist, then absolutely primary care physician. And the police officer, I think that I probably would be able to avoid having to call the police officer. And the reason is because I can use the police reports. If the police are called out, there will be a report. You can call public record, you know, their public records department of whatever agency it was, get a report of that. And if you need someone to talk about the report, it's likely the parents can do that. So probably wouldn't need the police officer to show that Alex had eloped and the police had been called, but maybe something happened during that incident that only the police officer saw and I really want them to talk about it. So again, all of this is very case specific. Okay. So let's move on a little bit. There we go. Okay. So when I was explaining some of this as I talked through the options, but you know, as you know, you have your list of possible witnesses, the list in the poll, and you want to go back again and look at that denial and look at what you have to prove. The denial in this case said there's not enough evidence to show Alex's autism is severe and pervasive. So I see not enough evidence. So I'm like, okay, let me get some more. Who has more? You know, what did they see so far? They saw A, B, C, and D. And oh, the speech therapist can talk about E that wasn't in the packet originally. So let me give them some more evidence. So if you have someone like that who has more evidence that wasn't included in the original packet, you know, that can help you address their not enough evidence. If you don't have a person like that, you might have to go back to the professionals who've already been working with Alex and get more data. You know, continue to gather data and submit that as your hearing approaches. Okay. So the next thing that the denial said was the IEPs say that Alex is friendly, engaging, and loves to learn. I see this a lot in APD denials for autism. And it's very frustrating. So what I do with this statement is I want to call the teacher and or, you know, any sort of behavioral specialist or other specialists working with Alex at school, you know, and hopefully it's someone who was in that IEP meeting and they can explain. And, you know, I'm going to want to talk to them and have them answer questions about, you know, does Alex is friendly, Alex is engaging, Alex loves to learn, but is Alex on track? Is Alex on grade level? Is Alex having behaviors in the classroom? Is Alex, you know, having meltdowns in the classroom? And have the teacher or the specialist give context to this. Yes, Alex is friendly and loves to learn, but that doesn't mean that Alex isn't having issues at school. And then the last thing in the denial was it said Alex's behaviors and symptoms associated with her autism may improve with services available through the school or community. So that's another kind of frustrating statement. Because who knows, maybe they will, maybe they won't. But the way that I would try to address that, and I put these particular statements in the case example because I see these a lot. So hopefully some of y'all, this is going to be directly on point to what some of the folks watching need to prove. So when they say that her behaviors may improve with services, I'm gonna ask and I'm gonna show, look, how long has Alex been getting services? Since she was 3, so 7 years of services. What all types of services has she been getting? How many weekly, twice a week, all day in school? And really try to drill down and say, look, Alex has gotten a ton of services and we are where we are right now. And this speculation that she may improve with services isn't really shown by the fact that, she's been getting services all along and we're still like here needing APD. So, and we'll talk more about that as we go through the different topics and go through the case example a little further. So next, I just wanted to talk a little bit about how you get your witnesses to the hearing. So you've decided which witnesses you're going to call. How do you get them there? If you have a parent, say Alex's dad is going to do the hearing, Alex's mom is going to testify. That's easy. Hey, mom, show up. Okay, sure. You don't have to do anything. For professionals, for people you're not acquainted with, for that police officer, maybe you're maybe gonna need a subpoena. So a subpoena is just a document that is issued by the hearing officer that tells a person, hey, you need to show up to this hearing. So it's, the technical definition, it's a legal document that requires a person or entity to appear in legal proceedings to testify. There's another kind of subpoena called a subpoena justus tecum, and it's a legal document that requires the person to come and testify, but also to bring documents. That's the only difference. So you don't have to subpoena all your witnesses. Like I said, if, mom agrees or teacher agrees or, therapist is like, yeah, sure, I'll be there. You don't have to subpoena those people. If you have someone who's not agreeing to come or who you can't get to return your calls, you may need to subpoena them. So you have to request your subpoena from the presiding officer, your hearing officer in your case, whoever's the, judge person. They're called hearing officers or ALJs, different things in different forums. And then once you get your subpoena, you've requested it, the hearing officer sends you your documents, and then you have to have them served. So you can do that. You can call the sheriff's office wherever you are, and they will serve the document, or wherever the person is, whatever county. You can call a process server, professional companies that offer that service, or you can have it served by anyone who's over 18 and isn't really is not interested in the outcome of the case. So if you have a neighbor, a friend, something like that. I've worked with students before and I've had students serve subpoenas. So it can be kind of anyone. I see that shocked face reaction coming up on the screen, and I certainly would not do that with anyone if I was worried about any sort of safety concern. Then I would want to call the sheriff's office in that case. But sometimes you're serving what are called friendly subpoenas, where the person's like, I'll come to the hearing, but can you give me a subpoena so I can show it to my boss because I need the time off work? And so they're expecting the subpoena. They want the subpoena. So that's when I send my uninterested adult, not in more contentious situations. Okay, next slide. So you've decided who you want to call. You got to figure out what you're going to ask them. So this is like this is the meat really of preparing for a fair hearing. So witness testimony typically has some kind of basic components. You're going to introduce them. What's your name? Who are you? Some people say, name and date of birth, or name and, I live in this city and state. You're going to want to then ask about their credentials and experience, whatever it is that makes them relevant to this case. So for Alex's mom, her credentials and experience are that she's Alex's mom and she's lived with her for her whole life and interacts with her every day. For the teacher, you know, you want to say she's a teacher, that she's licensed, she works at Alex's school, she's been her teacher for 3 years, or, you know, however long. You know, the doctor, the same kind of concept, you're licensed, you went to medical school, you've been a physician at this hospital for how long, and how long have you been treating Alex? How many times have you seen Alex? That kind of stuff. So credentials and experience. And then how they're associated with the case. So I kind of did those together. And then the meat, like the real substantive bit is, you know, whatever it is you're trying to get that witness to prove. You know, if it's the police officer, we're not going to be asking him about behavioral reports from school. We're just asking the police officer about those elopement incidents, right? And then after, you know, after a witness is examined, there's cross-examination followed by a redirect. So if it's my witness and I have Alex's mom testifying, I ask her all the questions, introduction, credentials, experience, the substantive questions. Then the other side, the agency, has their opportunity to cross-examine mom, and they ask their questions of mom. I might object to some of them. And then once they're done with their cross-examination, I can do what's called redirect. So if they asked a question on cross that I know there's more to that story, you know, I can go back and say, hey, they asked you about this. Can you tell the rest of that story? So you get, you know, one for me, number two for them, and then I get the third chance. And that's your examination. So when the rules are a little different, whether you're doing the cross-examination or the direct examination, the original first examination. So when you're asking questions in the beginning of your witness on direct, you know, I've called Alex's mom and I'm going to start questioning her. Your questions can't be leading. So I can't say, you're Alex's mom, aren't you? Instead, I have to say, how do you know Alex? And it's an open-ended question. Some of these rules are stricter for attorneys. In these hearings, when people represent them pro se, you are given more leeway. So some of this is, you'll be able to get away with some of this. But anyway, so your questions on direct, you should be short, about a single subject, and open-ended. You want to, you don't want to ask long compound questions that it takes them 5 minutes to answer. That will get confusing. So break your questions down into single subjects. And so you're going to limit the questions for each witness to what that witness is there to help you prove. Like I said, you're not going to ask the police officer about the behavioral reports from school if the police officer never was at the school. You're going to ask them about those elopement issues because that's what they saw. You don't have to ask every witness about everything you're trying to prove. And then the general warning that everyone gets and all lawyers get, and they yell at you 100 times in law school, is be careful asking questions you don't already know the answer to. So if you have a witness on the stand that you've talked to a bunch and you generally know what they're going to say, go for it. You know, if you have a witness on the stand and it's something you've never talked about, and they might say yes and they might say no, and you really don't know, you know, you need to be careful. How important is it to ask that question? If you can get that information from another witness that you know how they're going to answer, do that. Just don't ask the question. Be very careful asking questions that you don't already know the answer to. All right. So this is the second bit of the case example. So Alex's parents have decided to call her primary teacher, her ABA therapist, her speech therapist, and the psychologist who evaluated Alex. Alex's mom will also provide testimony. What types of questions should each person be asked? So again, as always, look to your denial and to the facts that you need to prove as far as medical necessity or your factors for autism or whatever service you're seeking. So I'm just gonna throw out some kind of general thoughts about each of these witnesses and the kind of questions that I'd be asking them based on that denial. So again, the denial said there's not enough evidence to show autism or Alex's autism is severe and pervasive. So I got to make up this case example, so I get to make whatever assumptions I want. So, but earlier on, we didn't hear anything about a speech therapist. So if there was no information in that packet about the speech therapist that could prove, I'm certainly gonna wanna ask my speech therapist about those things that were not included in the packet, right? And I'm gonna have provided documents ahead of time about the speech therapy and all of that, but I'm gonna go through each of these people and find out, okay, what else do you know about Alex? What else can you talk about her behaviors as they relate to those 6 of 12 factors that wasn't in the packet? And those are the kind of questions I'm gonna ask of each person. Alex's IEP says she's friendly, engaging, and loves to learn. So for that, I'm gonna be looking mostly at the primary teacher and then any other witnesses that have provided services in school. So like I was explaining before, if her primary teacher is going to testify, and of course Alex is friendly, engaging, and love to learn, but teacher, can you please talk to us about things that aren't written down in this IEP? Can you talk to us about what Alex's behavior is like on a day-to-day basis in your classroom? Can you talk to us about some recent incidents that have happened? Can you talk to us about how Alex is getting on and off the bus, those sorts of things that might not be mentioned anywhere in the IEP. Same thing with the ABA therapist, assuming the ABA therapist has been in the school and provided some services at school. I'm going to ask them the same questions. What can you tell me about Alex that isn't in that IEP that they didn't see yet? And that can give context to the statement that she's friendly, engaging, and loves to learn, because people can be more than one thing at the same time. Just because she's friendly and loves to learn doesn't mean she's not having, behavioral difficulties or getting sent home from school or those sorts of things. And then the third thing the denial said was Alex's behaviors and symptoms associated with her autism may improve with services available through the school or community. So that may improve with services. So that's going to inform the questions that I ask of all of these witnesses. So I'm going to ask that primary teacher, hey, what services has she gotten? How many years has she gotten them in school? What are you aware of? Because that teacher has access to her cumulative file sheet. She'd be able to testify about all of that, even if she wasn't providing those services herself. And I'm going to ask the ABA therapist as well, like, how long have you been working with her? How many sessions have you had? And show that this is ongoing. She's gotten lots of services. Same thing with the speech therapist. And then with mom, I'm going to want mom to talk about, what have you tried in the past? Who have you engaged? What services? How many different providers? Have you looked in your community to see if there are things you haven't tried yet? Oftentimes, especially when people are in rural communities, it's like, sure, maybe it would improve with services, but we don't have any service providers here. So, that's not a real option. It's not going to happen. So I'm going to think about all of those things while I'm planning my questions for mom. And then again, looking to the facts you need to prove. So any additional information that any of these witnesses can provide about, like I said, in the autism example, your 6 of 12 factors, if it's, a request for, durable medical equipment, you're going to look at the medical necessity requirements and ask your witnesses, any additional information they have that shows medical necessity. So applied to whatever your situation is. Okay, next slide. So this is a little bit about cross-examination, just some basic information. I did explain it a little bit before, but so, I was using myself and calling Alex's mom as an example, but you also get to cross-examine their witnesses. So anyone the agency calls, you can cross-examine them if you'd like. You don't have to. You don't have to ask them any questions on cross-exam. But if you do ask questions on cross-examination, some of the basic rules are that your cross-examination is limited by whatever they asked on the direct. So if all they asked about was the IEP, you can't then go ask about speech therapy on cross, because that's what's called outside of the scope of direct. So think of it like a funnel. On direct, you're asking, a universe of questions, and on cross, that universe can't get any bigger. It's generally going to be smaller, and then if you do redirect, it's going to be even smaller. So, and then on cross, you are allowed to ask leading questions. So if you're cross-examining, you can say, "You've never met Alex in person, have you?" You don't have to say, "Have you met Alex?" Especially if you know the answer to that question. So, the rules on cross, it's a little easier. You don't have to think quite as hard about how you're formulating your questions. And again, like I said, I think there's a lot more leeway given to pro se individuals in these hearings on rules like that, I would not enjoy that leeway if I were there. Okay. So talk a little bit about strategy on cross-examination. Those are some basic rules about cross. And so now think about like how to decide whether you actually want to ask any questions or not. So if there are parts of their testimony that you think that were wrong or poorly done, and I'll explain that, you can attack those, right? So if you have, what I mean by poorly done is if you have a doctor that's testifying for the agency that they don't think Alex qualifies, and all they did was read one IEP, but there are 10 IEPs throughout the years, or 5. And there's also speech therapy records that they never looked at, and ABA records that they never looked at. So on cross, I'm going to point that out. I'm going to be like, there's all this information and all you looked at was one IEP. To point out that, their conclusion isn't that, founded in the evidence. There's so much that they didn't look at. So that's what I mean by poorly done. They didn't do their due diligence when they were formulating their opinion. Or if they're just wrong, if their facts are wrong. And you can ask them, if you knew that Alex actually, they say, "Oh, Alex is verbal, she speaks fluently." And you come in and say, "Well, did you know she actually only speaks in single words?" And they'll say, "No." Okay, well, would that maybe affect your assessment if you knew that corrected information? So that's kind of like you're looking for stuff they've said that's wrong, or that they've just like done a bad job on, or stuff that's outdated, incorrect. If they're the only IEP they looked at was from kindergarten, Alex is 10 years old, like, let's look at the new ones. And ask them again, if you'd known this back then when you were making your analysis and coming to your conclusion, would it have impacted that? Or was there a potential that it could have impacted that? And I would never ask, "Okay, what's your new conclusion now that you know it?" Because I don't know the answer to that question, right? He'll probably double down and say, "Oh, no, I think it doesn't change anything." And now I've kind of ruined my own cross-examination. So did they base their opinion on very little information, very little time spent? Here's where I'm going to point out, you've never met Alex. Or how long did it take you to do your evaluation? An hour? To review a person's entire lifetime of, that's something that I would certainly point out on cross. You might attack their credentials or experience. This is a little iffy. But if their person has only been a psychologist for 1 year and your psychologist has been practicing for 30 years and has written 30 books and it's been on the Dr. Phil show or whatever, like, you might be like, "Oh, well," you might attack their credentials and their experience and point out that you've only been doing this for 1 year, like you don't have a lot of experience with this. But that's relative to the credentials of your experts, which you should know because you will have prepped for your hearing. And then again, the forever warning, just be careful asking questions you don't know the answer to, because on cross, you may not have ever talked to this person before, so just be careful. Okay. Case example. so we're gonna do a little poll with this, but I'm gonna read this prompt first and then we'll do the poll. So the agency's only witness was their expert psychologist who reviewed Alex's application package. The expert testified they never met or spoke with Alex or Alex's parents. They only reviewed the documents provided. The expert said they based the decision to deny services to Alex on statements from the IEPs that say Alex is friendly and engaging and loves to learn. The expert asserted that Alex's positive engagement in school means her autism is not severe and pervasive, and also that she's likely to improve through the services and education at school and through community providers. So, what types of questions might we ask this expert on cross? And I have a poll question if that can come up. So here are some types of questions. Let me know what you think about these if you think they're a good idea based on your facts. What types of questions? How they completed the evaluation, how much time they spent with Alex, whether they spoke to Alex's teachers, whether they spoke to Alex's therapist, what services might improve Alex's behaviors related to autism, whether there are appropriate school or community providers available to provide these services. And you can pick as many of these as you want. And again, I can't see the responses, so I will just wait for the answers to pop up. Okay, all right. So I'm sorry, I have a annoying cat. Okay, so it looks like everyone thought we should ask whether they spoke to the therapist and how much time they spent with Alex. And the one with the lowest people selecting it was what services might improve Alex's behaviors. And I 100% agree with that. So how they completed the evaluation, absolutely. How much time they spent with Alex, you should know that because you know whether they talked to Alex or not. If you're the parent of Alex. Whether they spoke to Alex's teachers, you can know that ahead of time too, because you're going to be talking to Alex's teachers. They're going to be helping you testify. So, and you can ask them, did APD ever reach out to you to discuss her case? Whether they spoke to Alex's therapist, same thing. You can know that ahead of time. What services might improve Alex's behaviors is a dangerous question because you don't know how that doctor is going to answer. And they might come up with something that sounds really good. And that thing may or may not even be available to Alex. It may or may not be something that insurance would cover for Alex. It may or may not be something that the parents are interested in approving for Alex. It may be a service they don't agree with, or it's against their religion or something like that. So having that doctor give a complete answer and listing out services makes it sound like there's all sorts of things that could be done. And then whether there are appropriate school or community options, I probably wouldn't ask that question either. He's not the best person to ask it to. And I think I can get Alex's mom to talk about what's available in the community in a way that's going to be much more helpful to our case, as opposed to him speculating, or this doctor, whoever they are, speculating about what services might be available in the school or community. I can have Alex's mom, who I will have talked to plenty, and have her talk about, well, we've tried all of these and there are no providers for that. And she can give actual accurate information on that that's helpful. So, okay, I am going to move on to documents. Okay, so using documents, some basic information. You can use the documents while you're questioning the witness. You can ask the ABA specialist to pull out their weekly data and explain it. You can also submit documents directly to the hearing officer, or the judge or the ALJ, whatever you're in front of, whoever you're in front of, and ask them to take notice of them. It's called judicial notice. So usually you're going to do this right at the very beginning of the hearing or the beginning of when it's your side's turn to present. So like right before you call your first witness, you might say, just briefly, Your Honor, will you please take judicial notice of this stack of documents? So, and they'll read them, they're supposed to read them and consider them, even if there's no testimony about them. You can use your own documents, or you can use documents provided by the agency, or both. If everyone has to submit their documents ahead of time prior to the hearing, so you know what documents they have, they know what documents you have. If you see stuff in their documents that you think is helpful, and you can go show it to your witnesses and say, hey, I'm going to ask you about this, you can use their documents. You have to submit your documents to your opponent and to the hearing officer prior to the hearing. The deadline for when you submit them depends on what forum you're in, so I'm not going to tell you that because I don't know your specific case. But it will be on your notices, the notices that they send you in the mail about your upcoming hearing will give you the deadlines to submit evidence. And it will tell you how and where to submit the evidence. If you don't turn documents over prior to the hearing, you may not be allowed to use them. The hearing officer can say, no, there was no notice of this, no one's ever seen this, we're not using this today. Parts of documents, you can use a part of a document. You can just say, here's page 3 of that psychological evaluation. Look what it says here in paragraph 2. But if you do that, the other side's allowed to say, there's a lot more stuff in that evaluation. I want the whole evaluation to be submitted. And the judge will order that. So if you've got a bunch of bad information in that evaluation and you want to cherry pick something out of page 3, the other side can force you to bring the whole thing in. And then, okay, so if your witness or the agency witness references a document that hasn't been included in the evidence, like I said, the hearing officer can deny you the ability to use that document or submit that document, but you can also just ask like, oops, or I only got this yesterday, can it now be submitted into evidence? You have to, send a copy to the agency, send a copy to the hearing officer, and sometimes that's allowed like right in the middle of the hearing, because it is true that sometimes things don't become available until after your deadline. And again, if you're pro se, you get a little more wiggle room, so it's more likely that you'll be allowed to do that. Okay, so aside from the basics of just how you use documents, you got to think about what documents do I want to use. Sometimes there are thousands and thousands of pages of records for a single individual. So, you want to use your strongest evidence and not kind of overwhelm the hearing officer and make it more difficult for them to rule in your favor. So again, you're looking to the denial and you're looking to the facts that you have to prove, whether they be 6 of 12 factors for autism or medical necessity or what have you. So we talked about how to decide what you're going to ask your witnesses. And then you want to think like, okay, which documents help them prove this? Which documents support what they're saying? Mom can talk about how she eloped twice. And then you can put into a police report saying, look, it's true. She eloped twice. And, perhaps that document gives more context and says, she was found in this place or with this person or in this dangerous situation, or it took this incredibly long amount of time before she was found. How dangerous, So, yeah, you're matching up your documents with your witnesses generally. Like I said, you can just submit them for judicial notice. But I think about this as like I'm gonna have a hard time explaining this, but those worksheets when you're in school and you have 2 lists and you have to match them and draw the lines from one side to the other and match the bullet points, like you maybe white goes with duck and black goes with night, and and you're drawing lines from one side to the other, right? Sorry if this is not the most clear example, but so in my head on, the first side, the first list is all the things you have to prove. It's from your denial, factors, factors, factors. And then on the other side is your witnesses and documents. So for factor one, who am I gonna call? Teacher, psychologist. For factor two, who am I gonna call? Police officer, use that police report. Factor three, and I need to have a connection I need to have a witness or a document for every single fact that I'm trying to prove or disprove. So you need to have one connected for each one. I hope that made a little bit of sense. Okay, so behavior, in here I have a little bit of an example. You're looking for documents to help your witnesses explain their testimony, behavioral reports that the behavioral specialist authored or used, IUPs that the school representative authored or implemented, police reports that describe the situation. And another just little tip is you can use documents that include weak evidence. You just need to be ready to address or explain it. So, say for example, you have the police report and it talks about the elopement and it says she's gone for hours and, she was found in a dangerous situation. But it also says that when the police officer picked her up, that, she was friendly and engaging. Okay. So you want to talk about the elopement, but you're going to need to address that friendly and engaging. And that might actually be a reason to call the police officer if you need to. But if we can have a witness explain, oh, mom saw what happened, like he said she was friendly and engaging because she smiled, but really mom was standing right behind him. She was smiling at mom. Like she was not happy to see that police officer. He was a stranger. She wasn't okay with it. Whatever. That's a kind of a weird example. But the point is if you have a document that has strong evidence you really want to use, but there's some stuff in there that's not so good, just be ready to address it. Don't try to ignore it. The other side will bring it up. Okay. So this is our last case example slide, and it will be our last poll. So on the slide, it says, Alex's parents have decided to call her primary teacher, her ABA therapist, her speech therapist, and the psychologist who evaluated Alex. What documents might Alex's parents use for each of these witnesses? It also asks the question, Alex's mom will also provide testimony. Since Alex's mom is not a professional, can we use documents during her testimony? If so, what documents might be used? So let's answer a little bit of this through the poll. So what documents might Alex's parents use during Alex's mom's testimony? So IEPs, prior evaluations, therapy records, samples of Alex's schoolwork, police reports, the letters from family complaining about Alex's behaviors. And you can pick more than one if you'd like. I wish I had a button that played Jeopardy music while we wait for poll answers. And one thing I don't think I've said is you can use the same document with multiple witnesses if you'd like. So, okay, so here it looks like the top answers, 7 out of 10, were prior evaluations and letters from family complaining about Alex's behaviors. And then below that was police reports, samples of Alex's schoolwork, therapy records, and then IEPs. So on this one, like, again, it all depends, and I know that is irritating for me to say over and over again, but I may or may not use all of these documents with mom. If I felt like the teacher or the ABA therapist or both of them were gonna adequately explain the IEP and contextualize it, I might not bother asking mom too much about that. Um, but maybe I would, especially if mom was the one attending the IEP meetings. If mom remembers why they wrote that statement that she's friendly and engaging, if there was specific context surrounding it. If mom asked them not to include it, but they did anyway, those sorts of things. Prior evaluations, I may or may not ask mom about those. Theoretically, I should probably have the person who conducted the evaluation do it. But if I'm only calling the one psychologist who most recently evaluated Alex, but I have, 3 or 4 other older evaluations, then yeah, I'd probably want to use those with mom and ask mom about those evaluations and what was said in them so that they can be contextualized. Um, Therapy records, same thing. If I'm not having if the speech therapist or the ABA therapist or whatever therapist can adequately address it and contextualize it, I may or may not ask mom about it. Samples of Alex's schoolwork. Again, depends on how much the teacher is able to shed light on that. I might ask mom about how much help she gives Alex with homework if that's a thing. Um, but yeah, and the police reports, that's probably how I'm gonna get those police reports in, because I'm most likely not going to call the police officer. So if I want someone to contextualize that report, not just have the judge read it and that's it. If I want additional context for that report, absolutely gonna use that with mom. And then letters from family complaining about Alex's behaviors had the highest amount of responses. And I think I understand why. But I may or may not actually use those. And here's why. Because like I said in the beginning, your professionals are considered a lot more credible. They're considered more neutral. Your family members, they probably want to help you. Most, that's the general assumption, is that families get along and help each other. So the hearing officer might put a lot less stock in what your family members are saying. But if there's certain incidents that no one else saw, we were on vacation in Idaho with relatives. The teacher wasn't there, police weren't there, therapists weren't there, only the parents were there. And you want to have more than just mom's word for it. You can pull in that letter when your family wrote and said, well, when you were in Idaho and that thing happened, it was terrible. So mom might be the only way to get those things. And so if there is good, important information in them, that isn't found anywhere else, then yeah. Okay, and again, I apologize that everything is so dependent on something else, but that's just kind of how it works. Okay. So a little bit of practical information about requesting documents. So there may be documents that the agency or the other parties thought would be helpful for you to have to prepare for your hearing or to bring to the hearing. You can request a document, you can make a request for documents to the agency's representative or their attorney, whoever's the one doing the hearing. And that person should be listed on your notices that you're getting from the court. So you don't have to wait for that deadline for them to submit their evidence. You can say, hey, I know y'all have a whole file on Alex. Send me what you got. So you can ask for broad requests or you can do specific requests. And so examples of those two things, a broad request might be all documents that the agency reviewed in making its determination on Alex's application. Or all the rules, policies, manuals, and training guides that the agency used to make the determination. Examples of specific requests are things like any notes created by the agency psychologist during their review of Alex's application, or all IEPs that the agency received from, the middle school. If you don't already have them, but they got them. So you can, if the school's giving you a hard time, just get them from APD. And Alex's parents are entitled to Alex's complete file, so it shouldn't be a fight to have them send these to you. But like I said, you don't have to wait until the deadline for them to submit their evidence packet. You can request this, as soon as your fair hearing has been set and you're for sure going to be doing a fair hearing, you can start requesting all of this. Actually, you can request your full file anytime you like, whether you're doing a fair hearing or not, just so you know. Okay, so that is all of my slides. Oh my gosh, we only have 5 minutes. So I'm gonna put on our info slide. If you want to contact us, if you have questions, this webinar is being recorded. And it will be on our website if you want to watch it again later. And we have a lovely survey. So please let us know if this was helpful or how we could do better next time. There's a QR code on the screen that you can use. There's also a link or a web address that you can use. So can I do a few Q&A questions, Robin? We have a few minutes.
Yeah, go ahead. Yeah, do you want to go ahead and ask them yourself, or you want me to? How do you want to do that?
So you got to read them to me and I'll do my best.
Okay. All right. So one of the questions is when the opposition's expert claims programs will, quote, likely result in improvement, would it make sense to ask, have you seen any improvement in Alex's behavior you can point to?
Yeah. I mean, again, it depends on if you know the answer to that question. If you know that all of the records show Alex's behaviors have only increased over time, then yeah, that'd be a smart question because we can say like she's been getting services and look, they just keep getting worse and worse. So your speculation is irrelevant because I have data.
Okay. All right, great. One person did ask to explain what the iBudget waiver is. Since we don't have very much time, can you do a really quick?
The iBudget waiver is a Medicaid program that allows you to receive services through what's called a waiver. And that waiver is for people with intellectual and developmental disabilities. And what you are waiving technically is your right to be institutionalized. So the waiver basically is supposed to provide you services you need to remain in your home or in the community. And the iBudget waiver is specific for people with intellectual and developmental disability. And in Florida, that is defined very specifically. You have to have a list of 1 of 7 conditions.
Great, thank you. What if my witness isn't available on the date of the hearing?
If your witness isn't available, then you can request a continuance of the hearing. If you really don't want to wait and you're ready to get this done, you might try to find a different witness who can testify to the same facts or documents that you can use instead of the witness. But if your witness is important and you really need them and you're willing to wait, you can request a continuance. And we recently did one of these about how to request continuances that is on our website.
We did. All right. Can I tell my witness what to say or what not to say?
Yes. So you can direct your witness, you talk to them ahead of time, ask them your questions, and it's smart to let them know like what you're trying to prove. Like show them the 6 of 12 factors and say, can you talk about any of these? And you can absolutely talk to them about what to say and like, hey, that fact isn't super helpful, maybe let's don't mention that. But you can't direct them to lie. So if the other side asks about that harmful fact, they're gonna have to answer it. But you absolutely cannot direct your witness to lie or kind of fraudulently withhold information, lie by omission, that sort of thing. But yes, you can absolutely strategize with your witness and have make sure they have a full understanding of why you're asking them to ask these questions and what the importance is of the various information.
Very good. Well, thank you, Caitlin. We appreciate you doing this webinar for us. There was one other question. I just want to let our audience know there was a question about whether or not we provide services to people with traumatic brain injury. And we do, and I'm just going to direct, because this isn't related to our webinar, I'm just going to direct you to our website where we do have some information. And if our website doesn't answer your question, you can certainly call our office or do an online intake, and they can answer some questions for you. So that is the end of our webinar. I want to thank everybody for joining us, and please have a wonderful day.
Yes, thank you.